Yeah, so I didn't say that. I'm Billy at Modern Law. I have a family law firm located in the East Valley and in Scottsdale. And this is one of the things that we do as part of our commitment to access to justice. A lot of people don't have access to the information they need. And so being able to take a whole entire litigation case and break it down into all the steps and components, um, we hope is a good resource for people who are representing themselves, or even if you're represented by an attorney, just having more information and being more informed about the process can just take a lot of the anxiety away and help you to make better choices, so that you're not always in reaction mode, or you're not spending money without really thinking about, is this money I have to spend and should I be spending it? What's the cost benefit analysis? So we talked about, okay, so we're gonna identify each issue that applies to you in your case, your best case and worst case scenario, what you can live with, the elements, how to determine what the elements are of the various legal issues, and then how to start thinking about what evidence you need to gather in terms of documents and witnesses in order to prove which elements. So we've really broken it down into a pretty formulaic manner, to maximize your ability to represent yourself if that's what you decide to do. And here today is where the legal analysis gets really important. Now, this is the part where, you know, paralegals can help with almost everything except for going to court and doing legal analysis. And that's why today's session is pretty darn important. And we're going to continue with the way that we've tackled this in the past, which is trying to look at it from a very formulaic, analytical, non-emotional perspective, even though we're dealing with, you know, your children and your spouse and your business and your money, and it doesn't get more emotional than that. I understand. But the best trial preparation begins months and months and months before trial, when we do all these other things that we talked about. Now, most of the time, you will, when you go to your pre-hearing conferences, which we've talked about in the past, and we've got a YouTube channel that has all of these, and we'll put the YouTube channel in the comments. We have too many YouTube channels. I'm not sure exactly where they're residing these days, but we'll find it and put it up. So anyway, where was I at?
Trial starts.
Yeah.
Preparation starts long before.
Right. Oh, okay. I was talking about the process. So
yes.
Yeah, you've got your filings, and then you've got your pre-hearing conferences, and then you're usually sent to some sort of mediation. And after that, you most typically have a status conference. And at that status conference is where you tell the judge either we've resolved everything, we've resolved something, and that is typically where your evidentiary hearing gets set. Not always. Sometimes in the very beginning, a judge will be like, okay, I'm setting you for trial, but most of the time that's not the case. So most of the time you've got a roughly 3 months or so notice, at least, to when you're going to trial. But that does not mean you should be waiting. All of these things that we've been talking about will help you get there. Now, we also have talked in the past specifically about Rule 69 agreements, where you can make partial agreements on any issues, anything, and lock them down and take them off the table for trial. I am a big fan of locking up whatever you can agree on. I don't care how simple it is. If you can agree on the personal property, great, make it a Rule 69 agreement. You can have 12 in your case. It doesn't bother me. I would just prefer to get whatever we can locked down, and off the table. And the reason that this is important is because when we're talking about trial prep today, one of the most important things to really pin down is what exactly are we going to be talking about at trial? If we've been able to get any issues off the table through Rule 69 agreements, let's say we've agreed on all of the children issues, then you know that you do not have to prepare any evidence on them. You do not have to make any arguments about them. You do not have to mention them. And in fact, if you do so, you're going to be wasting your precious trial time. So in our hypothetical, most typical situation, you're going to go to mediation. You're probably going to come to some agreements. And then you're going to have a status conference where you tell the judge, okay, we have some agreements, not all agreements. Here are the issues that are remaining, and we need X amount of hours for trial. At that point, trial will be set. Okay? Then what you're doing is you're looking at what is remaining, what are my remaining issues, which documents and witnesses have I already prepared and gathered, and what else do I need, and have I disclosed everything? We had a whole session on disclosures as well. Now is the time where you start making decisions and coming up with a strategy and executing your trial presentation strategy. You're going to identify which broad issues are remaining. So spousal maintenance is an example that we'll use throughout this presentation today. So let's say spousal maintenance is still remaining. The next thing we want to do is we want to look at the actual law, the actual Arizona revised statute on spousal maintenance and the words, because this is how you have to couch your arguments to the judge. This is the language that the judge thinks in and the way that he or she analyzes information. So that's the way we're going to present it, because then we're most likely to get the outcome that we want. So we're going to look at the statute, and then we're going to drill down in the statute to determine what are the various elements of the statute. Okay, so the statute says, 10 things. Okay, which of these 10 things must I prove, and which pieces of evidence apply to which elements? So we're getting very, very specific and formulaic. And if you have facts that don't meet these 10 elements for spousal maintenance, they don't get in. So we have to be real creative to think about, okay, it matters to me that my husband was out spending money on hookers. That's bad. We don't like that. What? But it's a no-fault divorce state. So you're allowed to cheat. There's no law against it. It's the judge doesn't care, doesn't want to hear about it. But if you spent money on hookers, that could be marital waste. And so now we can get it in under the statute that has to do with marital waste, because the court does care about where community property goes, but doesn't care about who you choose to sleep with while you're married or not married. So you're going to identify your facts and match them up to the elements that you've got in a statute. And I know feel free to interrupt me and ask questions, because I know we're in like legal zone here. But at that point, you're going to go through every single issue that you have outstanding, every single statute, every single element, all of your evidence, and that's going to be your final, that's how you determine what your exhibits are. So at this point, everything is coming together. You're going to end up with a pretrial statement, which is your entire case and history and facts and law all in one document. It's your outline for how you are going to present your trial. All of your exhibits are listed. Any objections you have to the other person's, it is your outline. It's like if you go into a test, this is your cheat sheet. This is the open note test, and you can take this with you. So you want to spend a lot of time. And if you're representing yourself and you have a lawyer help you with one thing, this is the one thing that it is worth spending money on, if you can, to get a lawyer to help you with. Let's say you feel like you're fine representing yourself in trial, that you can articulate yourself and you're well organized, and you're comfortable with all the exhibits. Still, getting help at this step will probably, cost benefit analysis wise, the best place that you can spend your money. So, and at this point, what you need to be doing is thinking about finalizing that exhibit and witness list. You've disclosed everything. We talked about Rule 49 in the past. We talked about discovery tools. You've disclosed everything to the other side, and you have ideally one disclosure statement that just has a million things listed on it. And as you supplement, I suggest we just add to the same list. Bold the new ones. That way you can look at one list to determine everything that you've disclosed and know when you did it. It just makes things organizationally a little easier. But so you're going to take this one list and start slashing off any pieces of evidence that you've disclosed that don't have to do with any of your remaining issues. So you've settled all the kid issues, but you still have the spousal maintenance issues. That'll help you determine which documents will become exhibits. Okay, so I think I jumped ahead a little bit, but that's okay. So yeah, this slide is all about how we're going to decide what we've agreed upon and what's still outstanding. But let's talk specifically a little bit about spousal maintenance. If spousal maintenance is an issue for you, one of the things that you need to do is the statute is broken into Part A and Part B. Part A is, do you qualify for spousal maintenance? Only if you prove Part A, that you qualify for spousal maintenance, do you get to go to Part B. So for instance, in the spousal maintenance or alimony example, you have to show one of the three qualifying factors. Either, number one, you don't have enough property, including the property that you're going to be getting in your divorce, to provide for your reasonable needs. Or number two, you're unable to be self-sufficient through appropriate work, and you lack the earning ability to be self-sufficient, or you're taking care of a child whose age and condition requires you not to work outside the home. Now, this is not for an elective stay-home parent, typically. This is for, let's say you have infant twins or triplets, and the cost of childcare for them would outweigh your earning ability. That may be an issue here. Or your child has special needs. He's had heart transplants. He's got, extremely specific conditions on what is needed for you to take care of him. That would be something that would typically qualify under this factor. Or the third part of A of the spousal maintenance statute is that you contributed to the educational or career opportunities of the spouse. This is specifically for, let's say you put your husband through medical school. You work as a nurse and work overtime and take care of the kids and put him through 8 years of school. And now he's met this new hot nurse and he's done. You have invested in his career that he gets to take with him, and that might qualify you for some basically compensatory spousal maintenance. Now in Oregon, where I'm also licensed or was also licensed, they have different types, and this would be compensatory. Yeah. And then the last thing that could qualify you for spousal maintenance is you've been married a really long time and you are of an age where you're probably not going to become self-sufficient through employment. Okay, so this is the doctor and his wife who've been married for 40 years, and the wife is now 60, and she's talking about going back to school to do, what, really? There's no way that she's ever going to catch up to the place where she's put herself and they put themselves. So at that point, if you're able to prove any of those things, then you get to go present all of your evidence on how much spousal maintenance and for how long. But you have to do it in order. You have to follow the statute. Now, we talked about this a little bit too. Identifying the facts that apply to each element can be tricky. If we go back to our spousal maintenance analysis, let's go with our hypothetical doctor and his wife who've been married a really long time. And let's say the wife doesn't have a lawyer and she's representing herself. Their situation is they've been married a long time. The kids are all grown. They have a lot of assets. Let's say they've saved $5 million in assets. He may try to argue that she has enough property to become self-sufficient. Now she needs to really think about her situation and think about, did I put him through school? Might I qualify under that factor if I don't qualify because I have too much money and property to meet my reasonable needs? And then the other question is, what are reasonable needs? Well, reasonable needs really comes down to you as an individual. Do you have some questions?
Yeah.
Okay, bring them on.
One of them I wasn't sure. Did I contribute to his career success if I worked in the call center and started a business? Started.
Yeah, so this happens a lot. I'm so glad you brought this up because we have another case where this is happening right now. A lot of times spouses will help each other open a business, whether or not they're both listed as owners. Now, did you contribute to the career opportunities? You've got a couple ways to go on this. Yes, you could absolutely argue that you contributed to the career opportunities, but the other thing is you've probably developed a big chunk of community property together. The house? Yeah, the house absolutely counts, but I mean the business. So if you built a business with your spouse, then that business is community property and it has a value, and you are entitled to the community share of the value of that business. Now, let's say you contributed to that opportunity, you helped build the business, and it's closed. There's no value. Well, then yes, you may want to go back to thinking about, did I contribute to the career and educational opportunities? Let's say that that business that you helped him start that's now closed was in some specific industry, like, I don't know, oil or whatever. And now he has special skills and contacts that he didn't have otherwise. So now he's got a job, he's employed. So you don't have a business to get your interest out of, but he wouldn't be employed in the field he's at if you hadn't contributed to his educational opportunities, career opportunities. So these are all of the different ways we have to look at, like, side by side, your case and the law, to figure out how are we going to present this evidence for the judge so that we can make it easiest for him or her to give you what you want. Let's not make them jump. Let's not make them do this work. Let's figure it out for them and present it in the way that they can most easily give you what you're asking for. Say yes. Okay. Yes. Okay. If you're doing the pretrial statement yourself, go to our sister site, accesslegaldocs.com, and download a template and follow the template, because I really can't stress enough how important this document is. It's not unusual for two lawyers and their clients to walk into court and to have a judge say, "Can I see you in chambers? I've read your pretrial statements. Here's what I'm thinking." Many decisions are made by that pretrial statement. It must be good. Do you have a question? No. Okay. All right. So once you've done this hard work, you've done your pretrial statement, and it says things like, we got married on this date, we filed for divorce on this date, we had a temporary order sharing on this date, our kids are this age and this. It's everything. It's, we came to these agreements, we didn't come to these agreements, these are the issues we agree on, these are the issues we don't agree on, here's why, here's all the evidence, here's all the witnesses. It's everything. Now, once that's done, you get to start preparing your testimony. And I think the best thing you can do is to use this pretrial statement as your guide. If you've done a really good job figuring out what is most important to you and putting it in this document, then you know that those are the things you need to talk about on the stand. And it'll help you stay focused. The other thing that judges tell lawyers again and again and again is that it's really helpful if we tell them what we're talking about right now. Right now, judge, we're talking about child support and we're talking about mom's income. Like, just be real clear. It might seem like you're being condescending. You're not. This is what they want. They want you to spell it out for them. They want it to be formulaic and basic. They have a lot of cases. So you want to tell your story, and it's okay to be emotional. But you want to stick to the point. You want to get the facts that you need to into evidence. And judges don't like anger. They don't mind emotion so much, but they don't like anger, and they don't like rudeness or disrespect. But, we'll talk about that a little bit more. Your pretrial statement can also be used to anticipate what the opposing party is going to say and rebut that, which is also helpful because if you're representing yourself, then you're going to do cross-examination. Cross-examination is where, the other side has told their testimony and you get to ask them questions about that testimony. If you've done a really great job in a pretrial about anticipating what they're going to say and rebutting it, then you know that those are the questions that you're going to want to ask on cross-examination. All right, so.
On the cross?
Yeah, go ahead.
Does it only have to pertain to what they
said?
Yeah.
If the rules were being followed strictly, then yes, you're limited on cross-examination to asking about what they talked about on direct examination. But in family court, in Maricopa County, you're so pressed for time, and you have the ability to call them as a witness. And since you get to call them as a witness anyway, you can pretty much ask them whatever you want, as long as it's relevant.
You were representing yourself.
Yeah. And I don't remember if I have a slide on objections, but let's just say I don't. Let's just talk about objections for a minute. There's only a few things that you can really object to in family court. Relevance is one of them. Lack of disclosure is another one. Redundant, like, let's say you've talked about this 5 times. My advice is let it go. Let them waste their time. You have an hour trial, they get half, you get half. Let them talk about the same thing 5 times. But should you be really annoyed and really want to object, that is a possible objection. Okay. So before you go into court, please take care of yourself. A lot of people will take a sedative or a small sedative or something to help them calm down. And I don't think this is necessarily a terrible idea. Please test it before you try it first day to go to court. See how it goes. But a lot of people, it's so nerve-wracking and so stressful. There's so much pressure that it's not a bad idea to do whatever you can to help stay calm. Don't have too much caffeine. Try to take care of yourself. Listen to soothing music. We talked last time about negotiation and how you can influence your emotions and how important that is, like scientifically in mediation to get great outcomes. Well, the same thing is true here. So you really want to do everything you can to influence those emotions. How to speak. Let's say you're there. What you don't want to, okay, so you're not telling the judge conclusions. This is something that a lot of even attorneys make this mistake of telling the judge essentially a conclusion, a legal conclusion. And the example that I have here is you don't want to say, he is such a terrible parent. He has been a terrible parent the whole time we've been married. He's never done anything. I mean, he's just a rotten, awful parent. He should never have children. That says nothing. It says your opinion. There's no facts here for the judge to use to make his or her own conclusions. So instead, you can say, my husband is an alcoholic. He drinks a 6-pack a day. I have photos here of him passed out with our children next to him. He doesn't pick up the kids on time. Here's the statements that show that the school has to call him 12 times on his days, and he doesn't supervise homework, because here's the school records that show that on the days that he takes them back to school, they don't have their homework or whatnot. The difference is you don't have to say this person's a bad parent. You are giving the judge the information they need to make the conclusions themselves, and they want to make these conclusions themselves, okay? Any questions on that?
Is there a good rule of thumb on how much is too much to kind of emphasize your point?
Yeah, I mean, that's a great question. So what we have to do is we have to think about, okay, how many issues do I have to address here in my time? If I have a 3-hour trial and my only issue is parenting time and custody or legal decision making, and you've got an hour and a half, then the 12 beers and the passing out, I would hammer that. I would talk about that a few times, maybe bring in a witness who saw it. Any drinking and driving testimony, I'm going to bring that in, those records. We'll talk about that a lot. But let's say I've got to do all the custody stuff plus the spousal maintenance stuff and some property division stuff in the same period of time. Now you got to go for your biggest bang for your buck. Get in, get out, make the point, and go. The other thing that I'll often do with people is, let's say they have something, they want to talk about marital waste, but they also have all these other issues. Then we might do a cost benefit analysis of saying, okay, your best chance here at getting what you want is really talking about these spousal maintenance factors. Maybe we forego bringing in your claim for marital waste in order to spend the time we need to really make these other claims that might be more important. So really, I think there's not a rule of thumb, but it's a decision-making process that you should be conscious about and not just go in and kind of haphazardly wing it because it's too important. You don't get to redo it. You really don't.
Maybe talk about the time frame that we get for trial.
Yeah.
Which is very short.
It's very short. And you always have the ability to ask for more time, but judges don't necessarily like to give you more time. And now there are those attorneys that sort of insist on having, super long trials, but most of the time you're able to get it done. Do you think?
I think so, but we talk really fast.
We do. We're succinct.
Present a 30-year marriage.
Exactly.
Yeah.
We have to be really strategic, for sure.
Do you think that children testify to make a point? Example, they're tardy from picking up the kids and the kids stand on the curb, so it's not really recorded by the school, but they're the ones that you know, that's the person who benefits.
This is so hard because like kids are witnesses in a very, you know, specific literal sense. Kids see stuff and they know stuff, but no, children will never testify. It's never going to happen. They could be interviewed through either conciliation services through the court, or you can have a psychologist of theirs testify, or you could have a court appointed advisor meet with them and write down what they have to say. So there are ways to get this crucial information in through third parties, but only if it's crucial information, not all the time. So we have to really be thinking about what are the other ways to get this information in. If they're standing on the curb, is there a neighbor who sees, who's an adult? Do they have a journal? Do your kids journal? Because that we can probably get into evidence. Do your kids text message their best friends and report this stuff? Because we can probably get their text messages in. But the judge is really never ever going to put a child on the stand in a trial between two parents.
If it's consistent behavior, couldn't you kind of just have a friend or somebody go and observe it so that there is an adult that could then testify to it or get a private investigator?
Yes.
Something like that.
Yes. I mean, if we've been proactive about this, if we identified 6 months, you know, ago that this was going to be an issue and we needed to create evidence and we didn't have any, then those are the things we're talking about. How do we make sure we can get this evidence? Because it's going to be crucial. All right, what do you do for courtroom etiquette? Be on time. Don't be late. Dress appropriately. Your clothes tell your story. I was at a CLE, a continuing legal education, and a witness consultant was doing a presentation. And she said, she went through the science of first impressions, which I'm not going to bore you with, but essentially people make judgments quickly based on visuals before you open your mouth. And we get so little time in front of a judge. We don't want them wasting any of these brain calories trying to reconcile what they think that you should look like with what you look like. If you are a teacher, like for this particular purpose, you need to make yourself a character in a story. Because we just don't have time. They're not going to get to know you as a human being and know that you are a teacher who's so fabulous with second graders, and on the weekends you have all your tattoos and you're red in the biker gang and you're really you just don't have time. So if the character is the teacher who invested in her husband's education or whatnot, you show up like a teacher in your teacher uniform. And I mean glasses, I mean your hair up in a bun. Just, I know this is not the time you get to express yourself, okay? Because it's just not that important in this context. So your clothes tell your story. I've told clients before, you need to shave your facial hair. It's out of control. Like you know, the mom is trying to say that you're this drug addict, military veteran with PTSD and mental health issues. You cannot go in looking scruffy. We got to get you put together. So, you know, these are things to think about. Your hair will grow back. Your tattoos, you can cover them up. It's fine. Express yourself later. Stand when the judge enters, sit when the judge tells you to, or he or she sits. No colloquialisms, no slang, no throwing shade. Like we say yes, we don't say yeah. We try to sit up straight. And it's probably the most formal setting that I'm ever in. It's more formal than church. It's probably more formal than funerals. There is judges probably demand more respect than police officers do. Just do it. Be deferential. People, especially people who are representing themselves, can be very angry about this and get really up in arms. Like, he should listen to my story, and how's he better than me? Well, he's not better than you, but this is the deal. This is the way it works. And if you are concerned with getting the best outcome, and that's what I'm trying to do, I'm trying to help you get the best outcome. Being indignant about the respect that is being demanded by the judge won't help your cause. Be polite to the opposing party. Say your honor or judge, not hey dude, none of that. Keep your responses in check. No arguing, no sneering, no scoffing, no all the time. Happens all the time. No, you can't do that, okay? You just can't. You have to really control yourself. Again, go back to maybe taking some of the chamomile tea. Yeah, anti-anxiety is whatever you need to. You can't, you got to check all of that. All right, you're going to be surprised. It's not going to go as planned. As prepared as you can be, you got to kind of fly by the seat of your pants and be prepared to be checked in and roll with the punches and go off script if that's what happens. The judge may end up taking you in a direction that you didn't know you wanted to go in, okay? So sometimes that happens to us. Our cases will get hijacked by a judge who wants to talk about things that we didn't think were important. Well, here's the deal. If it's important to them, it's important, period, end of story. Change your direction. If he starts asking you specific questions about something, it means that it matters to him or her, and that's what we need to talk to him about that. All right. Once you're done, you're probably not going to get a ruling. Temporary orders rulings have been coming out more real time, which is pretty darn awesome. But most of the time, if you finish trial, you're not going to have a ruling. It's probably, I don't know, what would you say, 90% of the time you don't have a ruling? 90% of the time. And a judge has up to 60 days to get you a written ruling. We should also talk real quick about exhibits. So your exhibits, you've prepared them, you've disclosed them. They have to get submitted to the court, to the clerk of the court, about 7 days in advance. Now, this doesn't mean that they go to the judge for the judge to review. And a lot of people feel like the judge will have looked at my evidence before I walked in. That's just not how it works. The way that it works is you've submitted it 7 days in advance. It's been marked by the clerk of the court, and it will be waiting there for you. When you want to use your evidence, a witness needs to offer the evidence. So you go to the table that in the courtroom and you pick up the document that you want, and it's marked as Exhibit 3, and you say, and this is what, you're talking about spousal maintenance, and you're talking about how you've contributed to your husband's career, and this is the document that shows that you did that, and then you say, I offer to omit Exhibit 3. That's how you get your exhibits in. And the judges will look at any of those documents that you have admitted into evidence because you've offered them. If you don't, if you walk out of that courtroom and you leave all those exhibits there and they have not been admitted or offered into evidence, the judge will not look at them. Okay? I know. So it really is. This is probably the most dense of our workshops. So if you're tuning in for the first time, the other ones are a little bit simpler. Once you get your decree, what do? You need to review it carefully because you have to make decisions quickly. If there's mistakes, we need to correct them. If you need to appeal it, you have 30 days. Like, there's decisions that must be made. Do not ignore this decree. Don't sit on it. And it may be a time where if you really don't like it, this is a good time for you to go get a consultation with an attorney who can tell you, yes, there are legal problems in here, we can appeal, or yes, there are factual things that need to be clarified, or whatever. Just some things can be modified, other things can't. Don't sit on it for too long. All right, and that's all we've got for today. I know we've had some questions that have come in throughout the week, and now's the time when we can open it up to anybody online or here to ask any questions about this or anything else that that may have come up in your case.
I'm just reading this real quick there.
Thanks, Kaylee.
I assume they don't want to watch the blank screen.
The blank screen of thanks for listening. Yes. Mm-hmm. Yes. So any questions? And if you prefer not to talk, you can just slide your question right over to Tracy and she'd be happy to read it.
One question that I got emailed to me,
Mm-hmm.
and I just want to touch on it because because I told the person that we would touch on it, but they didn't give me a ton of information.
Okay.
So maybe we could just give what information they might need to gather.
What's the question? I promise I'll answer it.
It's a little intense. It is, what are the odds of me getting my 14-year-old daughter to be able to come with me? And I asked for some further detail, but
That's what we got so far.
that's like,
What are the odds? Okay, well, let's start in the broadest sense. Arizona is a state that wants both parents parenting as much as possible. The default when you have two good parents or two fit parents, two non-neglectful parents, if you go in front of a judge, will be some sort of equal parenting time arrangement. When you have older children, that becomes slightly less likely. Older children, well, part of the parenting time statute is what do the children want? The ages, the wishes of the child, depending on their age and maturity level. So the older a kiddo gets, the more input they have. Because what happens is if a 16-year-old says, I'm not going to my dad's house, Mom, Dad, I'm not going, you're not required to pick up your 16-year-old and put her in the car and say, you know, you're going to your dad's house. At that point, they have realistically a whole lot more say over what's going to happen. So in this case, we've got a 14-year-old. What are the chances of them living with me? It's really fact specific. Where does he or she live now? Are they doing well in school? Why is it they want to come live with you? Do you have a history of neglect or violence or mental health issues or any of the biggies that might, or CPS history, things, criminal history, things that might prevent a judge from having your daughter or son come live with you? So I don't know how to answer it any better than to say it's extremely fact specific, but it's doable. There are plenty of cases that I've worked on where a teenager goes from living primarily with one parent, even in one state, to go living primarily with another parent out of state. So it's absolutely possible.
I think it's important to say there's no magic age though.
Yeah.
In Arizona, that a child gets to decide.
Yeah.
where he or she wants to live.
Even
Which
at
is our state
16,
anyway, but
right?
It's not a guarantee.
Totally. And the age at when, I mean, the age and maturity of the child, it goes down to about 6, right? 6 is probably the youngest. And even that, a lot of judges will be like, no, I don't care what your 6-year-old has to say, which I can understand. I mean, my 6-year-old doesn't get to, I don't even have a 6-year-old, but if I did, they wouldn't get to decide where they lived. Anyway, what else? What other questions do we have?
sorry, just checking on the quality.
Oh, are we blurry or are we okay?
I was
Blurry is lousy.
you know what? I think Facebook's too.
Okay.
Can I answer a question?
Yes, please.
Okay. What if the other spouse manipulates the child's emotions for the sake of hurting the other spouse? Kind of like a type of situation.
Yeah. These have to be the hardest cases. So question is, if one spouse is manipulating a child into rejecting the other parent or influencing the other parent's emotions, what can you do? It's really fact specific and it's really, really hard. In my opinion, what I do, and I don't know that this is even right, but what I try to do in those cases is minimize transitions. So while a typical case, a typical parenting plan might be like a 5-2-2-5 or a 2-2-3, where you're flipping back and forth quite a bit through the weeks. When there's potential parent alienation, I like to go week on, week off, or 2 weeks on, 2 weeks off, to get children as much time as they can with the, let's say, the vilified parent without the other parent influencing them. But you've got your work cut out for you. The court will sometimes order reunification therapy, which I have seen rarely work. Have you?
Rare.
Rarely. Rarely works. And a lot of the times in what I see is the reunification therapist says, let's go slow, the child's uncomfortable. And like personally, I think that's just not helpful. Not helpful. I think what's helpful is a parent and a child rebuilding a relationship. And the farther you can get away from the parent who's influencing negatively, and the farther you can get that child away from the parent that's influencing negatively, I think that's your best bet. And I'm not a psychologist or an expert at all. I've just seen a lot of these very, very heartbreaking cases not go the right way.
One of the questions that came in throughout the week was, when can a child get a phone? If I pay for the phone, can the child's mother take away the phone as a punishment? I want to be able to get a hold of my daughter, and the mom makes it impossible.
You know, smartphones are such an interesting issue now. Smartphones, dumb phones, but really smartphones, because what happens when parents don't agree on things like, should my kid be on social media? At what age? Should they have these accounts? Should they have unfettered access to their phone? Can the other parent restrict access to the phone? Can they restrict it all the time, or can they restrict it sometimes? Can they have them, check the phones at dinner and at nighttime and at sleep time? Or can they take it away the whole time the kid is with the other parent? There's no easy answer to this. I've argued before that, so legal decision making, separate from parenting time, and legal decision making is only big decisions like religion, education, medical, and personal care. I've argued in the past that this question, social media accounts and cell phones, can and should fall into that personal care. Have you done that too?
I haven't tried an argument.
Because I feel like it's a major decision, and it's probably one that should be tackled with both parents. So it doesn't matter if you pay for it or not. Unfortunately, that's not like a smoking gun. I pay for it, so therefore I get to decide. It doesn't work that way. The default rules is that whoever has the children during their parenting time can make decisions, day-to-day decisions on how they're parented, which would include access to phones. So I would highly encourage you to try to communicate. I mean, if we could start over, anything you can do to make your ex not your enemy, to try to stay focused on the best interest of the kids, will make your life and their life a whole lot easier. I know it's not always possible, but you can influence it. And the more you think about how you can influence it, the easier time you're going to have in the years to come.
So back to kind of parental alienation
Mhm.
question before. What if one parent gets on a stand and says the child wants to live with me, and they're really not the nurturing parent, they're the one that's trying to bash the other parent, but somehow they get that out in court? Is there anything that you can do to discredit that person or bolster your side to say that's a falsity?
Well, let's start with the fact that your kids' desires are not the end all be all on where they're going to end up. The question is, what is in their best interest? And so what I would recommend you do, this is a great example. I'm so glad this is coming up today, because what I would recommend you do is look at the factors under the parenting time best interest statute. It asks for certain things. It asks for things like, what is the relationship between the parent and the child? So what do you need to do? You need to offer evidence that shows you have a good relationship with the parent and the child. Instead of focusing on showing what a bad person the alienating parent is, my recommendation is you focus on what a good parent you are, and what a strong relationship you have, and the strong ties that you have to the community. And then you may also offer evidence that shows you can offer evidence to discredit the wishes of your child. Let's say the child wants to live with dad because dad lets the child stay up all night and drink beer with his friends and, party or whatever. You're going to want to offer that evidence that will undermine your child's interests and, wishes. But if your child, again, there's no magic age, but if your 16-year-old child says, I want to live with dad because I don't like my mom's house, and all my friends are near my dad's house, and I can walk home, and I'm more comfortable here, you may end up with your child living mostly with dad. And at that time, at that point in time, you really want to focus on the time you do have with your child and making it as high quality as you possibly can and building that relationship and thinking long term. Because if your child's 16, got a couple more years of this. Do not get caught up in the war. Think long term, so that you don't do so much damage to that relationship that you have a damaged adult parent-child relationship.
This one's kind of a long one, so bear with me here. I was recently granted custody of my 3-year-old by CPS out of Indiana. The mom was involved in domestic violence with her now husband. She was pregnant and he hurt her badly. My daughter saw the whole thing, which is why CPS took her. She's been with me in Arizona since October. The CPS case may be closing up soon. Can I file in family court for custody?
Okay, there's a lot there.
I said that.
All right.
Disclaimer.
Okay. So many interesting issues here, because when CPS gets involved, CPS, DCS, whatever, child services, that is through the juvenile court. You have a juvenile court case at that point in time, and they, DCS or CPS or whoever, DHS in Oregon, they take custody of the child, and then they make determinations on where the child will stay while they have custody. And they're kind of instituting custody orders, sort of. When they close their case, those custody orders go away because the state agency no longer has custody over the child. So at that point, when that juvenile case gets closed, it reverts back to the family court orders. So let's say in this circumstance, mom had a family court order in Indiana, and dad now has custody in Arizona. He's had it for a couple months through CPS in Indiana. If the Indiana case gets closed, mom can have the child go back to Indiana with her under the family court orders. Let's say there's no family court order in place. You know, mom and dad were unmarried parents, dad's in Arizona, mom's in Indiana. Here we are, no custody order at all. CPS closes its case in Indiana. Mom comes to get the child in Arizona. We have a problem at that point. We don't have a custody order. And so the next question would be, okay, well then can we get one? Well, if you've only been in Arizona since October, you may have a jurisdiction problem, because in order for a state to have jurisdiction over custody issues, the Uniform Child Custody Jurisdiction Enforcement Act, I don't even know if I said that right, okay, has been adopted in all the states, and it says essentially the home state of the child, the home state has jurisdiction, and the home state is where the child has lived for the last 6 months. That's not the only way to get jurisdiction, but it is the most prevalent way to get jurisdiction. So if dad files in Arizona after 3 months, he's going to have to convince Arizona that under some other feature of the UCCJAA, like most convenient forum, or what else? Is there a contacts one? There's these exceptions that don't come up a lot that allow a state to get jurisdiction. Let's say nobody lived in, let's say they had originally gotten a custody order in Illinois, nobody lived in Illinois. Now Arizona might be the best place to get a custody order. But anyway, so in this particular case, we've got a complicated fact pattern. We have to figure out, number one, is there a custody order in place or not? Number two, what's going on with mom? How long is that process supposed to last? Can we wait the 6 months before we file here? That sort of thing. So definitely worth a follow-up with a lawyer on that one.
Let's see. I currently have my kids most of the time. Their dad lives in Tucson and is getting ready to move to Chandler. We live in Goodyear. He is wanting to have equal parenting time or every weekend. I want to make sure I have some weekends with my kids, and I don't think it's good for them to be in the car for so long while he tries to get them to school on time. I just want the schedule. I'm not exactly sure how that question is. I just want the schedule to start the same.
Okay,
I'm not sure. Sorry.
maybe stay the same.
Stay the same.
Maybe.
Yes, it's likely it.
Okay. Lots of good stuff here too. All right. So we live in this massive, massive geographic metro area. So typically, if parents live in the same vicinity, we talked about this, there's this kind of preference and presumption for equal time when it's possible, both parents parenting, and it's both parents parenting during the week and on the weekend. So judges don't typically like to say, okay, mom, you have the kids during the school week, and dad, you have the kids on the weekends, because they're kind of different roles. It's a different, yeah. And so the preferences here tend to be where each parent has both weekday and weekend parenting time. And that was one of the things that came up in this question. So that, yeah, it's unlikely that if you go in front of a judge, dad's going to get every weekend. So then the next question as well, is dad going to get equal parenting time if he's in Chandler and the kids are in school at Goodyear? That might be an hour drive. Is that reasonable? Probably not. It's probably not reasonable that children would have to be picked up from school and driven an hour back, and then you could never participate in any sort of after school functions, or how do you get your kids to the concerts for music? Like it's probably more of a medium distance plan. Maybe you might see a plan that has that happening. Maybe you have long weekends every other week, so there's a couple days where you're in the car a lot. We have to just kind of work with reality and figure out, practically speaking, how to maximize each person's parenting time given the geographical limitations of living an hour apart.
So if they had a good relationship, that might be a good opportunity to say, hey, dad, move a little bit closer to school. If he's moving.
There's a lot of things you could do, and that's one of them. Dad, do you have to live in Chandler? The other thing you could look at is, mom, do you have to live in Goodyear? How long have the kids been in school there? The other thing that I've seen parents do is I've seen them pick a school in the middle of where they live. So there's a ton of options, and there's no like magic answer or best answer. It really depends on the kids and the parents and their works. Maybe mom works in Phoenix and dad works in Phoenix. And so even though they both live far away, the kids could go to school in Phoenix and everybody be in Phoenix. There's just a lot of options, a lot of things to look at.
So we have about 5 minutes left.
Mm-hmm.
I'm not sure if you want to cover any other topic just off the cuff there.
Do you think we missed anything today?
Maybe just explain what exactly exhibits are. I know you mentioned journals, but maybe talk about bank statements or things that maybe pertain to more financial stuff. Just so
can we see you? Here we go. All right. This is Tracy, our newest attorney addition at Modern Law. And Tracy's been an attorney here in Maricopa County for like 20 years. So yeah, that's a great question. Would you, go ahead and explain what an exhibit is and all that.
Well, an exhibit is some sort of documentation, like I mentioned earlier, a bank statement, a retirement account statement, something that has some backup, usually has some sort of credentials, like a bank statement would have the bank information on there. Sometimes letters from physicians with their letterhead, or a note from a teacher, things like that you're presenting to the court as an authentic document to back up whatever you're trying to get across to the court on a particular issue. So retirement account, for example, are generally split 50-50 in Arizona pursuant to community property. So the judge would probably want to see what the values are, so the judge can allocate them accordingly in the decree. The more information that you can get to the judge that's beyond just your testimony and has some sort of paper trail backup, the better it is.
Yeah, great point. All right, so that's all for today. We do these seminars on the first and third Tuesdays of each month, and we've covered now the procedure, and now we're going to get into the substantive law. And we talk a lot about it as we've gone through it, but next time is all about child custody. custody and parenting time and different parenting plans and issues that come up with that. And as always, if you have questions on some past seminars and you can't find them, let us know. If you have questions throughout the week you want to send them in over the next couple weeks, and we will for sure cover them next time. Okay, thanks so much. Bye.